Good morning, everybody, and welcome to our LBTT and ADS webinar. My name's Isobel and I'm joined by my colleague Bob Langridge to talk to you today about the ADS consultation that the Scottish Government is currently undertaking in relation to various changes to the ADS. The backdrop to this is really the increase in the additional dwelling supplement from 4% to 6% that happened on with effect from the 16th of December 2022 in the Scottish budget. And this increase, which was quite unexpected, applies to transactions completing after that date, unless you had a contract before the 16th of December. It actually says unless a contract was entered into. So if you have missives concluded before 16th December, this change doesn't apply. In relation to what you actually need to get into the old rates, well, the contract's got to be in writing, which is what you might expect. But perhaps surprisingly, the contract can be conditional. So it doesn't matter that the contract is subject to a number of conditions. The fact that there is a binding contract means that the old rates apply even if the conditions haven't been satisfied yet. Obviously, the ADS has increased from 4% to 6%, but when it first came in, it was 3%. So it's actually doubled since it was introduced. But there are a lot of complexities in relation to the ADS and a lot of perceived unfairnesses where taxpayers have thought that the way that the ADS operates gives an unfair result. And that's led to the ADS consultation that we're going to talk about today. So concerns were raised by stakeholders with the Scottish Parliament Finance Committee. There were a couple of evidence sessions where people raised the difficulties which taxpayers and their clients were experiencing. And points were raised with the Scottish Government as well. A lot of cases have been taken to the tribunal where taxpayers thought that the ADS really shouldn't apply. 18 of the 43 devolved tax cases that have been heard actually relate to the ADS. In most of the, in fact, all of those cases, the tribunal has had to say that even though the result may seem to be unfair, it is what the law says. And so the tribunal has no option but to apply the law. In some cases, the tribunal is very sympathetic towards the taxpayer because some of the results do seem to be a bit odd, to say the least. But that's a really good indicator of how much people think that there are issues with the current ADS rules. So faced with all of these concerns, the Scottish Government committed to undertake a review of the ADS in the 2021-22 programme for government, and the call for evidence, which we'll see on the next page, was issued in on 16th December 2021 and ran until the 11th of March 2022. And the key sort of areas that it addressed were the time limits for replacing main residents, how the so-called joint buyers provisions worked, how the economic unit provisions worked, some concerns about divorcing and separating couples, and also the treatment of inherited dwellings and how that can impact on taxpayers and cause ADS to be payable when it otherwise wouldn't be. That consultation closed on the 11th of March 2022, and there was then a long period of silence when nothing happened until the 8th of February 2023. And on the 8th of February 2023, the Scottish Government published a consultation paper with draft legislation for proposed changes, and that consultation is running at the moment. So if we move on to the next slide, you can see that the consultation runs until the 5th of April 2023. And it's worth saying that if you do have any points at all about these changes, it's very well worth putting your view to the Scottish Government, even if you only want to comment on one particular point. These changes are going to be made by statutory instrument. The Scottish Government say that they're going to try and introduce the changes before the summer recess on the 1st of July 2023. But that's perhaps unlikely because the parliamentary process itself takes 54 days. And the consultation, as we say, doesn't finish until the 5th of April 2023. The Scottish Government will then have to consider what has been suggested in the consultation and perhaps make changes to the draft statutory instrument that's been published. So they might be toiling to get this through before the summer recess, in which case it'll be not until the autumn. These changes, when they come in, will not have retrospective effect, so they'll only affect transactions going forward. Obviously in what we say this morning, you need to bear in mind that these are proposed changes and there may be amendments to them before they actually come in. So all of these changes are favourable to the taxpayer, although who knows if there might be unintended consequences, but that's the intention. Do they go far enough? As we'll see, there are some parts of the consultation where they've not done as much as people might have wanted. It's undoubtedly the case that there will be additional complexity for taxpayers and agents because of the changes which are being introduced, although they are a good thing in general. So good guidance will be essential, but also trying to spot any possible issues before the statutory instrument is passed. The first big change is on the time limits. As you know, I'm sure ADS is payable if you're an individual, if you buy a house, even if it's going to be your main residence and you own other properties. But if you're replacing your main residence, then ADS doesn't apply. And that will be the case if the taxpayer has disposed of a former main residence within 18 months currently of the purchase of the new main residence. And they're going to occupy the new one as their main residence, and they've occupied the old one within that 18-month period. Those time limits are being doubled to 36 months. So that's a straight replacement of 18 months with 36 months. And that's probably where we would have started from if the ADS legislation hadn't been published first. The ADS legislation came before the equivalent SDLT legislation. So we got 18 months and SDLT and LTT got 36 months. So on the replacing main residence, if you sell beforehand, you've got 36 months now, or you will have 36 months to buy the new main residence. This will obviously take transactions out of ADS, and will also help divorcing and separating couples. So the other side of the time limits is when you're trying to claim a repayment of ADS. So where you buy the new property before you sell, and then you sell afterwards. And there you have at the moment 18 months to sell after you've bought the new main residence. But the proposal is to change that to 36 months. So these increases in the time limits are extremely helpful, and will probably take a lot of cases which were sort of problematic out of ADS. But as you can see on the next slide, the 36 months isn't a straight increase. It's also kind of doubling the time period, because before it was if you dispose of the former main residence within the 18 months beginning with buying the new one, but now it's 36 months beginning with or ending with the day after the effective date of purchase of the new main residence. So you can look backwards as well as forwards, which will help in some cases.
Yeah, I think it's worth mentioning that that is also kind of quite a weird quirk in the legislation, because in the draft, what they have done is, rather than extending all of this into the replacement of main residence stuff, a lot of it seems to be in the recovery of ADS provisions rather than the exemption provisions, which is, to my mind at least, an odd place to put it.
It does seem like an odd approach. It's quite hard to get your mind around how all of this works, in fact. But if we move on to the next issue that was identified, inherited dwellings. And here there's really three things. One is that if you inherit a small part share in a dwelling, that can count for ADS, because you have to, under current rules, take the value of the whole dwelling into account. The other thing is that inheriting a dwelling is effectively outside the taxpayer's control, that somebody dies and that's never expected, and so on and so forth. But also it's not clear when an inherited dwelling starts to count as being owned by the taxpayer. So the fixes for inherited dwellings are probably a bit mealy-mouthed. Well, the first one is anyway. You can ignore a dwelling which is inherited after missives have been concluded for the purchase of a new main residence. And so if Bill has concluded missives to purchase a house which he intends to occupy as his new main residence, and inherits a house from his uncle before that completes, under current rules, he'd pay ADS because he owned two properties, but under the new rules, this new relief will mean that he doesn't pay ADS. So this new relief will be helpful to some people. Will it actually help many people, though? The average length of missives is 6 to 8 weeks, so most are concluded within that period. And sometimes missives are even concluded just before completion. So there won't be many cases where you inherit during that period. The other thing is that the date on which you inherit property is being clarified to when the executors have executed a disposition. So that is something that can be controlled. The executors could be asked to not execute a disposition until a later stage. The new relief will be helpful if the beneficiary was not aware of the position, but it probably would have been much more helpful to introduce a relief like there is for SDLT, where dwellings inherited in the previous 3 years are ignored. The next change is that if you are a joint owner of property, at the moment, every joint owner is treated as owning the whole thing, and so the dwelling's taken into account if the value of the whole dwelling is more than 40,000. And that means that small part shares can result in ADS being payable. The proposed change is that if the market value of your share is less than 40,000, then you're not treated as owning that dwelling. So if a dwelling is shared between a number of people, you look at the value of the share, not the value of the whole thing. So that is a good thing, and that'll apply not just to inherited dwellings, but across the ADS regime generally. So moving on to one peculiarity of this, at the moment, if you have a part share in a dwelling and you inquire more, that doesn't result in an ADS charge because you're already treated as owning the whole thing, although there might be LBTT. The effect of this sort of ignoring shares worth less than 40,000 has an impact on acquiring a further share. If Bungle, Zippy and George each own a third share of a property worth 90,000, under the new rules, they're not treated as owner of that. So if Bungle bought out Zippy and George, they'd have to pay ADS. Whereas with a higher value property, which was you were already treated as owning, you could buy out the rest of it and wouldn't have to pay ADS. So the inherited dwellings is probably fairly helpful in relation to the small part shares, but the ignoring only things that you would acquire before missives is included is not quite so good. Moving on to joint buyers, the issue here is that there's a lack of symmetry. Under the current rules, ADS is payable if either of the joint buyers owns more than one house, but to claim a repayment of ADS, both buyers have to dispose of a main residence. Or under that, the sort of relaxation that was introduced, you can have one buyer disposing of a main residence which they both lived in. So Jack and Jill each own a flat. Jack sells his and moves to rented accommodation. They buy a new main residence in joint names and pay ADS. In this scenario, if Jill sells her former main residence, they can't reclaim ADS as only Jill has disposed of a former main residence. Under the new rules, as we'll see on the next slide, if either person, or any joint purchaser disposes of a former main residence, that will allow the ADS to be reclaimed. So in that situation, it would be able to be reclaimed. Moving on to, if we move on to the next slide. The Scottish Government are looking at the joint buyer amendments a bit more closely because their policy intent was to allow joint purchasers to reclaim ADS where one of them disposed of a main residence and the other one doesn't own any other properties. But the way they've actually drafted it seems to allow the ADS to be reclaimed even if one of the joint buyers does own other properties. So if James owns 100 buy-to-let properties and Anne owns a flat which she lives in, they then buy a property in joint names and Anne sells her former main residence. Under the new rules, they'd be able to reclaim the ADS even though James owns other properties. So that's probably not going to survive, and there will be some changes to the SI, the draft statutory instrument, to affect that. If we look at a couple of cases that have happened or been heard, Dr. Crawford and Ms. Scott bought a property in joint names on the 17th of December 2019 and paid ADS. Dr. Crawford sold his property on that very day. She sold her property later, but they couldn't reclaim the ADS, bizarrely, because he hadn't sold his property within the 18 months beginning with the day after the effective date. So the wording of the legislation meant that they were snookered. But the new changes will mean that ADS could be reclaimed in this scenario. Dr. Gowdy and Dr. Sheldon He lived in a property which he owned until 31st of July 2015. The other party never lived there. They moved into rented accommodation and then bought a property in joint names. He disposed of his former main residence, but the ADS repayment was denied because only he had disposed of his main residence and they hadn't lived there together. So the change in 2017 would not have helped. Under the new rules, ADS would be repayable here, as only one of the joint owners has to dispose of a former main residence. So the joint buyers, a lot of situations where you couldn't have reclaimed ADS, you will be able to now. Moving on, I think Bob is going to take over now to talk about local authorities.
Yes, hello everyone. So starting off, there are a couple of new reliefs that are added. The local authorities relief is not an ADS relief per se, in that it doesn't just apply to ADS, but it is in fact a full relief from LBTT. And the idea behind it is that it should put a local authority seeking to buy affordable housing stock in the same position as, say, a registered social landlord, where a registered social landlord, if it meets certain conditions, can claim full relief from ADS. This will be put in the Act through a new Schedule 6A, and if the relief applies, it will switch off both the LBTT charge and the ADS charge. And there are only really two conditions in the draft legislation at the moment, so it'll be interesting to see if those are developed further. The first condition is that the buyer is a local authority, and the second condition is that the transaction is funded with assistance of a grant or some other form of financial assistance, either or being under Section 2 of the Housing Scotland Act 1988. So this isn't a million miles away from the registered social landlord form of relief, where one of the conditions is that there is, governmental funding for the acquisition. So that is broadly, I would say, a helpful relief. The next relief is a bit more tricky, and I'm going to spend a few minutes just talking through it. And this is a relief aimed at divorcing or separating couples where there is a matrimonial or a shared home. This is one of the areas that caused in old ADS a large number of issues, and I think is a bit of a lightning rod for how the old ADS could be perceived as unfair. The kind of issues we get into are the kind covered in these two examples. So first of all, Jack and Jill, married, own marital home in joint names. They separate and Jack moves out. The intention of the parties is that Jill is going to ultimately take title to the marital home, but she has to buy Jack out, and that will take some time. Jack rents for 2 years, and then he buys a new home. 6 months after he's bought the new home, he's able to dispose of his share in the old matrimonial home to Jill. Now, in this circumstance, the ADS charge is currently drafted bites on Jack's purchase, because at the time he buys the new home, he owns 2 or more. He owns the former marital home and the new home, and he's blocked from recovering that ADS charge, because in order to do so, he'd have had to have lived in the former matrimonial home as a main residence in the 18 months before buying his new home. So obviously in that example, the 36-month new time limits would be helpful for Jack, and that would solve it, but it doesn't solve all issues around matrimonial homes. Next example, Sarah and Susan, they are civil partners, they have 2 children, they own their shared home together. When they separate, as part of the separation agreement, they decide that they are going to hold this matrimonial home in joint names until their children are adult or at least out of school, which will be some years in the future. Sarah moves out and she goes to buy a new home. in this example, Sarah will pay the ADS, and again, because of the terms of the separation agreement, she's unlikely to ever be able to recover that ADS charge, because chances are she would fail the 18 months and she will fail the 36 months as well. So a new relief has been proposed to help purchasers of new houses where they have got an existing matrimonial home. And there are a number of conditions. Some of these, to me, read quite odd. The language on the slide largely reflects what's in the draft legislation. All these conditions need to be met. So first of all, at the end of the date of purchase, the buyer owns 2 dwellings. The first of those 2 dwellings was at any point in time before the effective date, so no 36 months here, the only or main resident of the buyer and their spouse or civil partner. That dwelling, the first of the 2 dwellings, is still the only or main residence of the buyer's spouse or civil partner. The buyer and their spouse or civil partner do not intend to live together again. And finally, the buyer retains an interest in the first dwelling in pursuance of a court order or a separation agreement. So a number of things, to me, immediately leap out of that set of conditions. If we just flip to the next slide. First thing is, the language around the first condition is quite different to the language used elsewhere in the Act, because it specifically says 2 dwellings. When you are looking at the gateway conditions to ADS, it is at the end of the day you own 1 or more. More than 1 dwelling. When you are looking at the existing kind of star-crossed lovers rules, it says that there can be only 2 buyers, but here it just says the buyer owns 2 dwellings. So is this just intended to cover cases where the only 2 dwellings are the newly purchased home and the existing marital home? I think the answer to that, based on the remainder of the wording, is yes, but that to me seems like an unusual and slightly unfair position to take. Secondly, on the next condition, this only applies to spouses and civil partners, so it doesn't apply to separations of cohabitants whose lives can be just as enmeshed as married people or civil partners. So it seems a bit odd that they are excluded. Thirdly, I would assume, given the general way that LBTT operates, that whether or not that marital home is the main residence of the buyer's spouse or civil partner is to be assessed at the effective date. So there is an element of the fact pattern that is going to be outside of the buyer's control here. It is going to depend on what their former partner has done with the marital home, if they still live in there as their main residence at the point their transaction happens. And obviously, if their partner has moved on and is maybe splitting their life between the existing marital home and a new partner's house, that could throw that condition into question. And finally, I would just question the requirement for there to be a court order or separation agreement. Clearly, not every separation where the family home is an important asset and important steps need to be taken with it will be backed by a court order or a separation agreement if the parties are able to deal with it on a moral, informal basis. The other issue I have with this draft legislation is that it isn't affected by any of the preceding things that Isobel has discussed to do with joint buyers. And it's not going to be affected by anything I'm going to talk about in a minute on single economic units either. And so that kind of issue we saw Isobel describe in the Crawford case still arises here. In other words, it's currently, and the draft legislation doesn't deal with this, baked into the ADS and the LBTT rules that it's sufficient for only one cohabitee to own 2 dwellings for the ADS to apply to everybody. And if you want to switch that off using an exemption or a relief, then both buyers need to qualify for the same exemption or relief. The joint buyer rules and the single economic unit rules extend these reliefs in specific circumstances, but they don't extend this. So you're still caught out by the classic kind of problem that you get in the ADS. To give it an example, Cassandra and Apollo own a marital home together, and when they separate, they do so pursuant to a separation agreement that states that the home will be owned by them until their children reach adulthood. Cassandra owns nothing other than the marital home, and she gets a new partner, Agamemnon, and the two of them decide to buy a new house together. Now, my analysis of the draft legislation as it stands is that Cassandra and Agamemnon will have to pay the ADS on the new home. Agamemnon is still treated as owning Cassandra's marital home because they will be cohabitants at this point. So he is treated, for the purposes of do you own more than one dwelling, as owning her marital home. In this example, Cassandra has met all the conditions for relief. She only owns 2 properties. There is a separation agreement. However, Agamemnon doesn't meet all the conditions for relief. He's treated as owning a share in this marital home, but it wasn't at any point his main residence. His former spouse doesn't use it as their main residence, and he's not subject to the separation agreement. So those baked-in rules still apply here, which means that the ADS charge applies and isn't switched off. So I think as currently drafted, this relief is of limited utility and usefulness. And I think it has a pretty big flaw in it, which is those lack of symmetry provisions that exist in the ADS are still there, even though other bits of the legislation attempt to ameliorate them. Just a comment here, what I would do differently if I was trying to draft for this on the next slide. Number one, I think you have to extend this to cover cohabitees. There doesn't seem to be any moral justification for only applying it to spouses and civil partners. I would suggest it is fair to drop the only 2 requirement or loosen up that wording. Otherwise, you will have situations where a person who owns a stake in a marital home and maybe a buy-to-let is in a worse off position than someone who is selling their house and has a buy-to-let, because that sale of a prior main residence franks your purchase no matter how many other homes you own. But here it seems you can't own any other homes, so it's a very narrow relief, and I don't think that's quite right. And secondly, I would probably change the way that the relief operates. So rather than being a straightforward relief, I would say maybe you deem them to have disposed of the former matrimonial home within the prior 36 months, and that opens up the things like the joint buyer rules, which allow other people to benefit from your disposal. Or I might even just extend paragraph 5, which is the bit of the ADS legislation that says if one of you's caught, you are all caught, to say something along the lines of if one of a spouse, cohabitee, or civil partner can benefit from an exemption or relief, then the other can as well. So I think there is some work to do on the matrimonial home stuff. Finally, onto the single economic units. This is again another source of confusion because it is one of the areas where people assumed from guidance and what was available publicly that the single economic unit rules had parity, so that they work the same in both directions, and they don't. The original single economic unit rule says that spouses, civil partners, or cohabitants are treated as owning what each other owns. but only for the purposes of seeing whether at the end of the day of a transaction, one of them owns one or more dwellings, and not for any other purposes. The proposed change in the draft legislation would extend this to cover disposals as well. So a spouse, civil partner, or cohabitant will be treating as owning what the other owns, but also treated as disposing of the property disposed by the other. That is on the surface a very helpful change, but there are a couple of odd things about it that perhaps mean it has limited utility again. First, as it's drafted, it only applies to the recovery provisions, so to the reclaim provisions in paragraph 8, but it does not apply to the exemption for disposing a main residence, which is in paragraph 2 of the Act. So it looks like superficially you can recover if you dispose after the fact, but what about if you dispose of a main residence before you make your purchase? One possible answer to that is that, as we discussed before, the revised drafting to paragraph 8 is a bit weird in that it looks both forward and back, so maybe it gets you there, but it would just be more logical to extend this to cover the exemption, I think. The other point I would make about this having limited utility is in cases where spouses, civil partners, cohabitants are going to be joint buyers, which you would think would be the majority of cases, then they're already covered. The extensions to paragraph 8 that Isobel talked about to do with joint buyers do the job already. So what else does this add? I could only really come up with one sensible scenario where the extended single economic unit rules do something that the joint buyer rules can't. And that is where you have your main residence owned by one member of a couple, they sell, and then a new main residence is bought by the other member of the couple. So it covers you in situations where you don't have joint buyers and where the spouse disposing of the prior main residence is not themselves the buyer. So if we imagine Martin and Lawrence married, live in Martin's flat, Martin is the sole owner, Lawrence owns 2 buy-to-lets, presumably one of them was his home before he met Martin, so this is not an uncommon setup. Lawrence decides that he's going to buy a new house and that will be their main residence, and he funds that by selling one of his buy-to-lets. He's not lived in any of these for 5 years, let's say, so it doesn't count as a replacement of main residence. Then 2 years later, Martin sells his flat. Now, in this example, the single economic unit rules help, because even though the ADS is payable at the time of purchase, Lawrence owns more than one dwelling and is not replacing a main residence. When Martin sells his flat 2 years later, they should be entitled to a recovery. The joint buyer rules don't help you, but by extending Martin's disposal to Lawrence, the recovery provisions are opened up. Is there an element of unintended consequences to these? Potentially, because when you add together the joint buyer rules and the single economic unit rules, you get some slightly weird results which probably aren't intended. For example, Lionel and Lily are spouses. They live together in a house owned in Lionel's sole name. Lily has a sister, Pat, who, for whatever reason, Lily is going to jointly purchase a property with Pat. Presumably, Pat doesn't have enough money for the deposit. Lily will help her out. What Lily gets out of this is a share of the profits when the house is sold. Pat owns a buy-to-let, but before purchasing this flat with Lily, she has been a long-term renter. 2 years after the flat purchase, Lionel then goes on to sell his house. Now, in this example, it seems that Lionel's house sale is going to allow Pat and Lily to effectively recover their tax, even though Lionel's not a party to the transaction. And he's not a partner to Pat either. They've got, Lily and Pat have to pay ADS on the purchase. They're both treated as owning more than one property. Lily because she owns the house of Lionel, Pat because she owns a buy-to-let. And they can't recover, but they can recover this arguably when Lionel sells his house, because the disposal is imputed to Lily under the single economic unit rules. And if Lily has made a disposal under the joint buyer rules, both Lily and Pat can benefit from that. So that is quite a weird result, probably something that the Scottish government may revisit. That kind of covers at a high level the main changes and some of the potential issues we see with these, and that we are going to go back on. So we've got a few minutes left. I'm just going to open this up to any questions.
One of the questions is about exceptional circumstances and whether there's going to be an exceptional circumstances provision, which means you get longer than the 36 months to do the replacing main residence. And the answer is no. The Scottish government decided not to introduce that, even though it exists in SDLT, just because of the difficulty of sort of policing it, which is a shame. Many people will be helped by the 36 months, but there are situations to do with, for example, cladding or other fairly catastrophic things where it takes much longer to sell or indeed to buy. So it's perhaps a shame that an exceptional circumstances provision hasn't been introduced.
Agreed. And there's a fairly egregious tribunal case called Christie, where, I mean, the decision is correct in terms of the law, but a buyer was in the military and had been posted abroad and was unable to live in his house within any of the requisite periods, and ultimately wound up being liable to the ADS without the ability to recover. And that is the kind of thing where you think, you know, exceptional circumstances should apply. Someone else has asked, if a local authority buys a house to let or sell to a person with special needs, will it still have to pay the ADS? It sounds as if it will. I think arguably it does. Yes, it depends how the purchase is funded. That is really the fundamental condition in the relief as it is set out. And if that is not funded by a grant or under Part 2 of the Housing Scotland Act, then it doesn't look like the relief as currently imagined would apply. And I think Scottish Government are slightly aware of this. They make the point in their response or their analysis of the consultation responses that, for example, there's no easy statutory definition of affordable housing that they could use in framing the relief, which is why they went with the grant provision. Albeit,
it sounds as though
there are bits of legislation you could refer to for, you know, housing someone with special needs.
And it sounds as though this deserves to be exempted, doesn't it? So it does sound that it deserves
to be exempted. And in some cases, it might be exempted if, for example, it's already used for housing someone with special needs. You could argue that it is not residential property if care is included, but obviously that's no help where you are sourcing a new property for a specific person.
It might be worth suggesting to the Scottish Government that this new exemption is extended to deal with situations like this. So it's well worth raising.
Agreed. One final question before we wrap up. Someone has asked, in our view, does this solve all of the ADS cases that have been before the tribunals? I think the answer, and Isobel, say if you disagree with me, is probably no, but it probably, a lot of this legislation probably solves the really, really bad ones. You know, the most
Agreed.
egregious cases are probably fixed. Some of the cases, for example, the Christie one, are not fixed potentially. As we've shown, you go through the webinar, there are still circumstances which are highly plausible where you get an unfair result. And of course, there are some ADS cases where I think the answer is legally correct, but also quite fair. For example, the case of someone buying two properties next door and then knocking them through into a single dwelling. I think that was rightly subject to the ADS, and I think that is consistent with the policy intention. So I hope that sort of part answers that question. Right, that is everything from us because we have come to time. If anyone has any further questions, you know, please do feel free to email myself or Isobel at the contact addresses here. We will be sending out a recording of this webinar either. All right, thank you all. Goodbye.
Thank you.